Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Tonight's lecture is going to be on Chapter 5, where we will be covering justifications and defenses. And we're going to look at a couple of different types of defenses and the process of what we call affirmative defense, and then we'll look at issues relating to justifications or excuses, if you will, as those terms relate to this particular chapter. So with that said, let's go ahead and jump right into chapter 5 tonight. So by way of introduction, two recent homicides that captured headlines around the nation and throughout the world illustrate the concepts behind legally justified homicides. And whether you agree or disagree with those cases, we can argue that at a different time. Right now, I'm just trying to lay out some information as it relates to what are considered justifiable, non-justifiable homicides in the eyes of the court and the different defenses that were used. So, the first was the fatal shooting of Michael Brown by Ferguson, Missouri police officer Darren Wilson back on August 9th of 2014. Now, Wilson testified at a grand jury hearing that Brown attacked and struck him while he was seated in the patrol car, and that during a struggle between the two, Brown reached for his firearm. Now, Wilson was able to retrieve his gun and fire twice, striking Brown in the thumb. And Wilson further testified that Brown then backed away from the police car, and when Wilson exited the car and basically said that Brown subsequently charged him. In response to that, Wilson fired 10 additional rounds, with 6 striking Brown. Now, although there was no question that Wilson shot and killed Brown, a grand jury investigated the shooting and chose not to indict Wilson for homicide. And the decision not to indict was grounded in the law of justification and excuse, specifically in this case, self-defense. Now, the Ferguson grand jury heard the testimony of many eyewitnesses. As is true in so many cases, the eyewitnesses varied in what they said. However, the bulk of the eyewitnesses and the forensic evidence supported most of Wilson's testimony, if you will. And the incident was highly polarized, especially along racial lines. And protesters, if you remember, in Ferguson and cities across the nation demanded that Wilson be tried, while others defended his actions. Unfortunately, some of the pro-prosecution protests turned violent, and people were injured and private property was destroyed in the resulting riots. Subsequently, 2 New York City police officers were executed while sitting in their patrol car in Brooklyn. The shooter had posted racial comments on his social media accounts describing the hatred of police and referencing Wilson's shooting of Brown. Now, the second case occurred on February 26 of 2012 in Sanford, Florida, when 17-year-old Trayvon Martin was shot and killed by George Zimmerman, a 28-year-old community watch coordinator. Now, Zimmerman told police that he had shot Martin in self-defense. Initially, the prosecutor who reviewed the case decided that the shooting was justified, but Zimmerman was later arrested amidst public outcry and charged with second-degree murder by a special prosecutor appointed by Florida's governor. Now, the night of the shooting, Martin was visiting with his father and his father's fiancée at her home. They had been watching a sporting event on TV, and Martin left the house to walk to basically a convenience store. And Zimmerman saw Martin walking through the neighborhood during the young man's return from the store, thought he was suspicious and followed him and called the police. And there's an audio tape on that you can hear. and apparently ignored a suggestion from the police dispatcher to discontinue following him. And this ultimately led to a confrontation, and where Martin was fatally shot. Now, Zimmerman claimed that Martin knocked him down, banged his head against the ground, and so he shot him in defense of his life. And as was true in the Brown shooting, race was assumed by many people to be a factor in the Martin shooting, and claims that Zimmerman, who was Hispanic, was motivated to follow Martin because he was African American, and that contributed to the making of the incident, or this incident being kind of a national cause. And the media frenzy and the basic rush to judgment was pretty fast and furious. And there were protests calling for Zimmerman's arrest, and in some instances, immediate punishment sprang up around the nation in the weeks following the shooting. Now, Zimmerman didn't deny that he shot Martin. Instead, he asserted self-defense, a defense that has a stronger foundation in law in Florida than some other states, because Florida has what they call a stand your ground law. And the stand your ground law empowers individuals to use deadly force to resist life-threatening or limb-threatening, if you will, attacks without having to first retreat. And central to Zimmerman's defense were the injuries allegedly received by Martin. Now, from Martin. So I have a clip of the Trayvon Martin murder case, and I'd like you to watch it at your leisure because it is an interesting video, and it does show some of the defense aspects that were brought up, because we're going to be talking about the different types of defenses that are used. So a defense consists of evidence and arguments offered by a defendant and his or her attorney to show why that person should not be held liable for a criminal charge. And generally there are two types of defenses, and those are factual and legal. A factual defense is one in which the defendant simply asserts that he or she didn't do it. An alibi, when a defendant claims not to have been present at the location of a crime, is an example of a factual defense. And some cases, even when a defendant has committed illegal acts in question, a legal defense may shield a defendant from conviction or punishment. So again, we're talking two types of defenses, factual or legal. The factual defense, the defense simply asserts that he or she didn't do it. And an alibi is probably the easiest example I can bring up as a factual defense. Now, a legal defense, there are two forms. So two forms of legal defenses are justifications and excuses. And I'll give you the legal definition of these two, and then we'll talk about them in a little bit more detail. So a justification, a type of legal defense in which the defendant admits to committing the act in question, but claims it was necessary in order to avoid a greater evil. Now, an excuse, on the other hand, is a type of legal defense in which the defendant claims that some personal condition or circumstance at the time of the act was such that he or she should not be held accountable under criminal law. So again, the two forms of legal defenses are going to be justifications and excuses. So justifications, when the defendant admits to committing the act in question but claims it was necessary in order to avoid the greater evil, if you will. And then excuses, this is when the defendant claims that some personal condition or circumstance, if you will, at the time of the act was such that he or she should not be held accountable under criminal law. Now, the difference here is that In the former, the actor did the right thing in the circumstance. Example, defended himself against an assailant or destroyed property to save life. While in the excuse, the rectitude of the actor or his action is simply irrelevant. What is relevant in an excuse, relevant to penal law, is that for reasons of either incapacity or extreme pressure, such as a threat of immediate death or something like that, the actor should not be held criminally liable. Instead, he is excused. Another author explains the difference between justification and excuse this way. A justified actor engages in conduct that is not culpable because the benefits outweigh the harm or evil of the offense. An excused actor admits the harm or evil, but nonetheless claims an absence of personal culpability. Now, generally speaking, conduct that a person believes is necessary to avoid a harm or evil to himself or herself, or to avoid harm to another, is justifiable if the harm or evil to be avoided is greater than that which the law defining the offense seeks to avoid. So hence, justifications may apply when people find themselves facing a choice between the lesser of the two evils. So with that, justifications and excuses are very old concepts. And again, what is common to both, though, concepts is that an injury or damage has been caused by a human being. The difference, just to kind of reiterate, in the former is that the actor did the right thing in the circumstances, self-defense for an example, while an excuse claims that some personal condition, okay, or circumstance at the time of the act makes them basically not responsible, okay? And sometimes this is referred to again as facing a choice between the lesser or of two evils. So again, an excuse does not claim that the conduct in question was justified, but that the actor engaged in it was at the time not legally responsible for his or her actions. Now, I have a really good clip here. We don't have time to play it, but this is the Scott Folater sleepwalking case. I think I referenced it in another chapter earlier as well, but this is a great case where this individual ends up killing his wife, and he claims sleepwalking as the defense. He is subsequently convicted based on a large number of circumstances and a lot of good evidence along with eyewitness testimony on one particular aspect of this case. So watch this case. It's only, I think, about 20 minutes long, but I think it will help really add some context to what we're talking about in relation to types of defenses. Well, let's talk about the process of affirmative defenses. Now, affirmative defense is an answer to a criminal charge in which the defendant takes the offensive and responds to the allegations with his or her own assertions based on legal principles. Okay, so justifications and excuses fall into that special class of defenses known as affirmative defenses. And these affirmative defenses are different from other defenses because they impose burdens on the defendant. Unlike other defenses, these place the burden on the, that should be production and persuasion on the defendant. So the defendant has to prove, okay, that there was something that was either justifiable or an excuse. So unlike other defenses, these place the burden of production and persuasion on the defendant. And another issue is failure to raise an affirmative defense in a timely manner has serious consequences, and here the defendant loses the right to present the defense at trial if they don't raise this in a timely fashion, if you will. So a successfully raised defense may have the effect of completely exonerating the defendant, or the defendant, completely exonerating the defendant of any criminal liability. And when claims offered by the defendant are not sufficient for a verdict of not guilty, they may still mitigate, meaning lessen, the defendant's liability and result in a lesser punishment, if you will. And so when we talk about these, again, these justifications as a defense, justifications are going to include the following. So these are justifications: necessity, self-defense, defense of others, defense of home and property, resisting unlawful arrest, and consent. All of these are areas of conduct, if you will, that where that conduct violates the law, but it may be justifiable. So let's take each one individually and we'll look at it. So strictly speaking, the concept of necessity, which is our first one, forms the basis of all justifications, if you will. A defendant offering the defense of necessity makes the claim that it was necessary to commit some unlawful act in order to prevent or avoid a greater harm. Now, in most jurisdictions, individuals are privileged to protect themselves and others. So again, necessity, a defense to a criminal charge that claims that it was necessary to commit some unlawful act in order to prevent or avoid a greater harm. Now, the Model Penal Code, the MPC, says that the principle of necessity is essential to the rationality and justice of the criminal law. And the MPC states necessity can only be claimed where the evil to be avoided is less than the harm caused. The next area that we will look at will be self-defense. And defense of self has long been accepted as justification for activities that might otherwise confer criminal liability. And self-defense is based on the recognition that a person has an inherent right to self-protection, and that to reasonably defend oneself from unlawful attack is a natural response to threatening situations. Now, similarly, it can be argued that a person who acts in self-defense lacks the requisite mens rea, remember, guilty mind, okay, for the commission of a crime. That is, a person who kills an attacker does not have as his or her primary purpose the taking of another life, but rather the preservation, if you will, of their own. Okay, so this is an important piece of this self-defense thing. And the Model Penal Code asks us to decide whether the defendant subjectively believed that the use of force was necessary. And to do that, there is a what we call the reasonable person requirement. And this requirement mandates that the accused behave as a reasonable person would have under the same set of circumstances. So, as we will see coming up in Chapter 6, the requirement that the use of force in self-defense be reasonable mandates that the accused, again, behave as a reasonable person would under the same set of circumstances. And in judging any activity, the reasonable person criteria requires that the the assumptions and ideas on which the defendant acted must have been objectively reasonable, in that the circumstances as they appeared to the defendant would have created the same beliefs in the mind of an ordinary person. So hence, anyone motivated by special needs or driven by psychological forces not routinely present in the average person may find that the claim of self-defense is not available to them in jurisdictions that impose this reasonableness requirement. So hopefully that makes sense. And along with that, and we talked about the concept of reasonable person here in judging the activity, but I want to get to the next piece, which is what they call apparent danger. And this is apparent danger is another concept associated with self-defense. And apparent danger exists when the conduct or activity of an attacker makes the threat of danger obvious and imminent, and danger becomes apparent when a suspect points a gun in a threatening manner. And if you look at the picture that I put up here, while the clerk definitely looks pretty calm, actually, there is a very inherent danger in this particular picture, if you will. And I think anybody that might be under the same set of circumstances would kind of feel the same way. So danger, for example, becomes apparent when a threatening individual draws a gun, a knife, and approaches another person in a menacing fashion. And the emphasis on imminency and present occasion found in many state codes classifies forceful activities undertaken in self-defense as justifiable only when they occur within the context of a face-to-face encounter. So hence, whereas a person who uses force to fight off an unlawful attack is justified in doing so, someone who stalks and kills a potential attacker in a preemptive strike might be hard-pressed to claim self-defense. Likewise, a person who might take the law into their own hands and exacts vengeance on a person who has previously victimized him or her cannot be said to be acting in self-defense. In short, the victim had it coming is not a valid self-defense, if that makes sense to everybody. So again, the emphasis on immediacy and present occasion found in many states that the codes classifies forceful activities undertaken in self-defense as justifiable only when they occur in that face-to-face type encounter. So with that being said, then, well, what is force? And how do we define that? Because we're going to have to define it, especially when we're talking about the self-defense factor here. So force, as used within the context of self-defense, means physical force. It doesn't extend to emotional, psychological, economic, psychic, or other forms of coercion. And individuals may also protect themselves in the face of threats when the threat implies that danger is present in a given situation, even though the precise nature of that danger may not be imminently apparent. So with that being said, we're going to talk about, reasonable force. And let's finish this up, though. The amount of force used by those who seek to defend themselves from unlawful attack must be proportionate to the amount of force or the perceived degree of threat that they are seeking to defend. So it needs to be reasonable. Well, then what is reasonable? But let's look at an example. If somebody, has a very small stick, let's say, that they might be coming to strike you with or something like that, would it be justified, would it be reasonable for you to pull out a handgun and shoot them? And maybe under some circumstances it might be, but remember, the amount of force used by those defending themselves must be proportionate to the amount of force or perceived degree of threat that they are seeking to defend against. Well, what's reasonable? Well, reasonable force is the degree of force that is appropriate and not excessive in a given situation. And it's also referred to as the minimum degree of force necessary to protect oneself, one's property, a third party, or the property of another in the face of a substantial threat. And deadly force, by definition, is that force likely to cause death or great bodily harm. And here it is. So this is the highest degree of force, and again is considered reasonable only when used to counter an immediate threat of death or great bodily injury. Now, deadly force, for the most part, cannot be used against non-deadly force, okay, unless there are other circumstances, other aggravating circumstances that might be added. And once the danger has been averted, the use of force must cease. So an example of that is we have two individuals that are fighting on the front lawn, and they're striking each other, and one person pulls out let's say a screwdriver, and the other person pulls out a handgun, and at that point the person with the screwdriver runs away, and the other person chases them, follows them into an alley, and then shoots and kills them. So remember, deadly force, okay, counter an immediate threat. So can you see a possible problem with that situation? So once the danger has been averted, the use of force must be de-escalated or in fact cease. Now, the claim of self-defense is usually unavailable to those who precipitate or incite an attack on themselves, and that's one thing that we need to remember. And there's a couple of other rules that we're going to talk about really quick. One is the retreat rule, and the other is the stand your ground. So the retreat rule requires that a person being attacked retreat in order to avoid the necessity of using force against the attacker if the retreat can be accomplished with complete safety. So if you can do it safely, there are jurisdictions that say that you need to do this. On the other hand, the stand your ground law permits the use of deadly force to repel life or limb threatening force in public spaces with no duty to retreat. It does, however, require a reasonable belief that the use of force is needed to repel a threat to life or limb. And I have a video that talks about the Florida law when it comes to the stand your ground rule. So if you want to take some time to read that, you can. And this is the same rule that was there relating to the George Zimmerman case. So that case, which was featured at the beginning of the chapter, relied on Florida's stand your ground law in his defense of the second-degree murder charge. And it reads in part, just to kind of let you hear what it sounds like, a person is justified in using force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend him or herself or another against the other's imminent use of unlawful force. However, a person is justified in the use of deadly force and does not have a duty to retreat if, 1, he or she believes that such force is necessary to prevent imminent death or great bodily injury to himself or herself or another. 2, under those circumstances permitted pursuant to, and then it gives the Florida Castle Doctrine, and we'll talk about the Castle Doctrine in a little bit. So there are some circumstances that are applicable to the stand your ground rule. And it also talks about defense of others. So another item under self-defense is the perfect self-defense rule. And a claim of the self-defense that meets all of the generally accepted legal conditions for such a claim to be valid. So this requires that in light of the circumstances, the defendant reasonably believed it to be necessary to kill the decedent to avert imminent death or great bodily harm, and that the defendant was neither the initial aggressor nor responsible for provoking the fatal confrontation. Now, the defendant must not have been, the initial aggressor provoking the fatal confrontation here for this to be applicable. Defense of others. When another person is being victimized, you can stand in the shoes of the victim and can use whatever force the victim could have used or could use in that person's defense. And I've got a couple of news photos from news stations that talk about armed hero stops purse snatchers, or wife shoots at men robbing husband. So you are allowed to, again, stand in the shoes of the victim and can use whatever force the victim could use in that person's defense, and that's the defense of others. And then another one is the alter ego rule. And this is a rule in some jurisdictions that holds that a person can only defend a third party under circumstances and only to the degree that the third party could act on his or her own behalf. And states that follow the model penal code do not recognize this alter ego type rule. So just a little bit of information. And this, under this rule, they allow a person to act in defense of others if the actor reasonably believes that his intervention is immediately necessary to protect that third person. And force may be used against others to prevent them from hurting themselves as well. So again, kind of an interesting thing. What about defense of home and property? And we get a lot of questions on this. Am I allowed to, shoot a burglar coming into my house? Well, defense of property can apply in the following situations: protection of personal property, defense of home or habitation, defense of another's property, or use of a mechanical device to protect property. Now, there are some different things in here that we'll talk about, and we'll see how this kind of goes about. So in 1999, for example, businessman Richard Mathis, 34, of North Augusta, Georgia, was arrested and charged with assault and battery with intent to kill after he opened fire on two burglars at his mobile home dealership. After the dealership had been repeatedly burglarized, Mathis decided to spend the night at the business protecting his property. Upon hearing a break-in, he surprised the two alleged burglars and fired shots in their directions with a semi-automatic rifle. One burglar, Douglas West, was slightly wounded on the face and neck by flying shrapnel. The use of mechanical devices to protect property is a special area of law too, because generally speaking, deadly force is not permitted in defense of property. The setting of booby traps, things like spring-loaded shotguns, electrified grates, explosive devices, and those things are generally not permitted to protect property. So, I mean, there's a couple of exceptions that are, again, kind of interesting in here when we look at this property thing. So, in most jurisdictions, however, the owner of property can justifiably use reasonable, non-deadly force to prevent others from unlawfully taking or damaging that property. And the preservation of human life outweighs the protection of property. The use of deadly force to protect property is not justified unless the suspect of the illegal act may intend to commit a violent act against another human being. So there's a lot of different ins and outs as it relates to defense of property. And, again, in most jurisdictions, the owner of property can justifiably use reasonable non-deadly force, not deadly force, unless there are some other aggravating factors. Well, what about that thing called the Castle exception that I talked about? Well, an exception to the retreat rule that recognizes a person's fundamental right to be in his or her home and also recognizes the home as a final and inviolable place of retreat. It is not necessary under this exception to retreat from one's home in the face of immediate threat. even where retreat is possible, before resorting to deadly force in protection of your home. Now, some states have not codified or codified, however you want to say that, the conditions under which the use of force in defense of the home is justifiable. A few states have extended the castle rule to automobiles, but not to public places generally, locating these states between retreat states and stand your ground states in terms of self-defense and, different types of justifications. However, so, to kind of go back to the question on this castle, exception, the castle exception can be traced to the writings of the 16th century English jurist Sir Edward Coke, with a C, who said, "A man's house is his castle, for where shall a man be safe if not in his house?" And again, this exception generally recognizes that a person has a fundamental right to be in his or her home, and also recognizes the home as the final place of retreat. That is, the home offers a place of retreat from which a person can be expected to retreat no further. Hence, it is not necessary for someone to retreat from one's home in the face of immediate threat. So, to answer your question that you've been kind of pondering while I've been talking about this, there does need to be an immediate threat. And especially in California, how you will be judged on that type of thing will be the reasonableness clause again. Would somebody under a similar set of circumstances done something similar, or used the similar or the same amount of force, if you will? So that kind of answers that question. What about resisting an unlawful arrest? Well, all jurisdictions have laws making it illegal for a person to resist a lawful arrest, and most jurisdictions provide statutory protections, written laws, to law enforcement officers who find it necessary to use force to effect an arrest or to prevent individuals in their custody from escaping. In California, the Penal Code is Section 148. And we talk about execution of public duty defense precludes the responsibility of arresting officers being prosecuted on charges of assault or battery, as long as the officers acted in a lawful manner. And a lawful arrest includes making the purpose of the arrest known to the person being arrested and using a valid arrest warrant. And there are some other circumstances that fall underneath there. And deadly force may be applied only to prevent death or threat of serious injury to the public, or to protect the law enforcement officer from a defendant who resorts to the use of deadly force, or a third party that might face the possibility of death or threat of serious injury. And there's a very, very big time famous precedent case, Tennessee versus Garner from 1985, that I would highly suggest that you look up. And that pretty much changed the way law enforcement dealt with deadly force across the United States, and started the framework eliminating some things like the fleeing felon rule, or using deadly force on property crime suspects, etc. And then finally, consent, a justification offered as a defense to a criminal charge, claiming that the person suffering an injury either agreed to sustain the injury or accepted the possibility of injury before the activity was undertaken. And consent is only available as a defense if lack of consent is an element of the crime. Some institutions have advocated requiring express consent, which is a verbally expressed willingness to engage in a specified activity. And in the heterosexual arena, it generally places the burden of ensuing that consent has been obtained on or by the man. Now, because the public has an interest in the protection of citizens, consent is generally not available as a defense in cases of homicide, or where the injury inflicted serious bodily injury. So think of Jack Kevorkian, those that assisted individuals in suicide, and things like that. Consent, again, cannot be claimed in cases of intimidation or fraud. intimidation or the threatened use of force to obtain consent invalidates the consent given and may result in charges of extortion or blackmail against that particular threat maker. Okay, so I know that was a lot to cover, but we covered a lot of things that fall under justifications and defenses. And again, just as a quick reminder, make sure that you go through the summary at the end of the chapter and look at those kind of larger nugget areas that they're highlighting for you, that I'm sure you'll probably see on a quiz question or something like that. And also take the time to look at the key terms and try to have a good understanding of the definitions of those terms as well. So with that being said, that will conclude the Chapter 5 lecture, and until next time.